We're session A4, correct?
That's correct.
Yes.
And we are live and on the record. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning and welcome to the Appeals Court. I'm Chief Justice Mark Green. With me on the panel for all 6 cases this morning are Justices Amy Blake and Jeffrey Kinder. All 6 cases on our list for hearing today are civil matters. We will hear argument in the first 3 cases, followed by a brief recess, and then continue with the remaining cases on the list. The first case on our list for hearing is case number 2020 P1052, Richard Smith versus Adam W. DeSisto and another. Mr. Tassel.
Good morning. May it please the court. My name is Neil Tassel. I represent the appellant in this matter, Mr. Adam DeSisto, who is present now on the YouTube live stream. By any reasonable objective metric, Mr. Adam DeSisto is a suitable person to possess an LTC in the Commonwealth of Massachusetts. This is a man who is now 40 years old, had an LTC and possessed firearms between 2006 and 2010 without any issue, without any difficulty in the proper use or ownership of firearms. During that time, he also had an LTC or a license to carry issued by the state of New Hampshire, again, with no issues pertaining to the safe use and ownership of firearms. He maintained this LTC that was issued by the appellees during the entire time of his alleged involvement with drugs, during the entire time that he was being prosecuted for a single half bag of heroin that was found on the ground adjacent to where he and his passenger were taken to the ground after being arrested by the same officers who testified, at least one of them, at the LTC hearing in Malden District Court. They allowed him to keep his LTC during that entire time. And it wasn't until months after the case was ultimately suppressed and dismissed in the Lynn District Court did they ever act against his LTC, a suspension which he did not appeal at the time. He's a man who manages a retail establishment, has an unblemished employment history, has no documented history of drug use, drug treatment. He has never been accused of selling drugs, and he is certainly not a man who has ever been accused of trafficking drugs, as the appellees claim in their brief to this court. In 2019, he applied for another LTC and was denied on the grounds that he was unsuitable. Not that he was disqualified anyway, he is not. He was rejected on the grounds that he was arrested in the case that was ultimately dismissed after being suppressed for the half-gram bag of heroin on the ground near him, and that an informant claimed that he was involved in the sale of Percocets. Despite this, in the 38 years of combined experience in the town of Wakefield, a town in which he is a lifelong resident, Mr. DeSisto was never identified even once as being a person who was a troublemaker, a person who had a violent nature, a person who had surfaced in other drug investigations.
Mr. Tassel, can I interrupt with a question, please?
Yes, Your Honor.
For all the reasons that you're summarizing, reasonable minds might disagree regarding the evidence of suitability. My question has to do with the standard of proof and our standard of review. When the judge uses terms like, the district court judge, that is, the evidence was too thin and too stale, doesn't that suggest that the judge was reevaluating the weight of the evidence rather than applying the standard of review?
Well, it's a way of looking at the evidence, and it's my belief that that was a factual determination made by the district court. To look at that in any other way would completely gut the petition to appeal a denial on suitability grounds. It would actually, I suggest to the court, completely undermine the purposes of, particularly of the 2014 amendment, to give some teeth to the petition when suitability is challenged on appeal.
Well, what
Not
is
on-
the standard of review? I mean, like Judge Kinder, my understanding in the first instance, at least, is that there is a broad range of discretion afforded to the local police chief to weigh and consider the various criteria and factors bearing on the ultimate determination of suitability. And then on review, yes, there is judicial review to guard against an abuse of that discretion and a patently unreasonable application of those considerations. But going back to Judge Kinder's question, is the judge entitled to conduct a de novo assessment of her assessment of the suitability, or how much deference is she required to extend to the police chief?
Well, it's clear that, particularly after the 2014 amendment, that there can be a review to determine solely whether or not there has been reliable and credible evidence that the decision is based upon, and whether or not the factors that are relied upon by the chief demonstrate a risk to public safety. Now, Simpkin, for example, and this court's decision in Phipps they show that when a factual basis is provided by the issuing authority, which is not credible or is not reliable and does not bear on public safety, then the district court has the decision-making ability to reject that specious determination.
So let's take the facts of this particular case and break them down. I want to see hone in, I guess, on the areas that you contend bear on this, and see where we may or may not disagree. To the extent that there was credible and reliable evidence that an individual is or has been engaged in the sale of illegal drugs, would you agree that would be permissible grounds for denial of a license to carry?
I suppose it depends how close in time it is. I imagine that there could be some break in time which was sufficient to dispel any notion that their continued their issuance of an LTC would not undermine public safety in any fashion. But if the evidence was reliable and credible, it certainly could be considered.
Okay, so we've got two instances here where there are indicia, at least, that incline in that direction, as determined by both the police chief and endorsed, at least in that determination, by the Superior Court judge on certiorari review.
Well, and yeah, I didn't mean to cut you off, sir.
Well, and one of those you contend was impermissibly considered, and that is the evidence from the confidential informant that he had in fact engaged in a purchase of illegal drugs from the petitioner.
Absolutely, I don't think it's appropriate to consider that evidence.
Okay, do you have any case that supports the contention that the exclusionary rule applies in a civil proceeding of this nature?
Well, I do. Yes, I cite this city of Framingham decision, and the appellant respond with the appellee responds with the Kelly matter, both of which are civil proceedings in which go in different directions on whether or not suppressed evidence ought to be considered. I just want to circle back on one point, though, is that this pertains to the suppressed evidence that was found on the ground, the half-gram bag of heroin, not the informant specifically. The suppressed evidence, I don't think should be considered, given that it should not be used in an evaluation of whether or not a person has access to a constitutional right. The distinction between the Kelly matter cited by the appellees and even the city of Framingham decision, which go both ways on whether or not in a civil matter suppressed evidence ought to be considered. But there are other, I cite also some case law related to government forfeiture, where the government is not supposed to be able to cite suppressed evidence in forfeiture matters. By the same logic that it's not appropriate to consider evidence which has been suppressed, particularly when it's being relied upon by the government to obtain some type of function.
Mr. Tassel, what about the district court judge's finding that your client was not honest in his testimony before her?
Well, I think it bears on two things. First of all, obviously that was her opinion. It's her factual finding. It's before this court. I don't think that her findings suggest in any way that it's related to a risk to public safety. It would be human nature, perhaps, to waffle about when a judge asks you, "Have you ever used drugs?" and to say no. The old "I didn't inhale" type of scenario. She may have picked up on something in that regard, but lack of candor itself does not reflect on public safety. The cases cited by the appellee.
But is it part of the totality of the circumstances?
Not on the decision of public safety, I don't believe. It could in certain ways, but in the facts before this court, whether or not 7 or 8 years ago, Mr. DeSisto, who, according to the officers, has no other involvement with drugs before or after, if he ever indeed did at all. And the cases cited by the appellee, Costas, Catucci, Callaway, are totally an opposite on the point of whether or not, strictly speaking, waffling about whether or not you've ever used drugs 7 or 8 years ago bears on public safety. It doesn't. And I think ultimately that was on balance what the district court decision reflects. That
Mr. Tassel, I didn't see anywhere in the district judge's decision the words abuse of discretion, arbitrary or capricious, or absence of grounds. Shouldn't that be significant for us in our review of whether or not the district court judge was employing the proper standard?
I agree that she should have used those terms, but the context of her decision makes it clear that she was applying the appropriate legal guidelines in issuing her decision. It was clear that she was saying that based on this mountain of evidence that he is a suitable person, it's an abuse of discretion, insert in the blank, that to think that these allegations from 7 or 8 years ago ought to overrule, as a factual matter, his suitability. And I do note that it would have been appropriate for her to use those terms because that is clearly between the lines in everything that she writes in her decision. Now, jumping, because I think some of Justice Green's questions in the courts go to whether or not, even if it were true, that 7 or 8 years ago, now more, there was some involvement between his next door neighbor, Mr. DeSisto's next door neighbor, who had a search warrant executed on his house for Percocets. I think everything in the district court record suggests that he was being essentially set up by the person who was the passenger in his car, a person who, as you can see, shortly after these cases ultimately had a school zone violation dismissed, and he was given probation for 18 months in the same court. A gentleman arrested by the same officers who arrested him, and one of the officers who testified in the district court in this case. Even if that were true, that he had some involvement kind of on the periphery of his next door neighbor or the other individual in his car, there's no evidence that justifies thinking that today that the manager of a retail establishment, that a person who has all every indicia of responsibility and safe prior gun ownership still is affected by whatever involvement he had during that time frame.
Well, when we ask that question, we're looking not at today. We're looking at the time of the decision that's under review. Is that correct?
Yes, that's where the facts exist, and that was, we're talking about an allegation of him surfacing an investigation in 2011, 2012, and then applying in 2019.
Right. So you suggest that that 7, 8 years is too long ago for it to be adequate to support a good faith suitability determination by the chief.
When the drug allegation is as minimal as this, with no evidence at all of any persistent problem, I suggest that that's the case. And it contrasts with Nichols, where you have this long-standing drug use problem, a situation that results in over 400 criminal charges in various jurisdictions. And that's the type of thing I think that even a reasonable inference suggests might persist. The allegations, and they were simply allegations that were entirely undocumented with respect to the Percocet, Mr. DeSisto. There's no way that in the present time, at the time the application is filed, without pure speculation for a chief to believe that there's still an unsuitability concern that creates a risk to public safety. And looking at the clock, I can see if there aren't any other questions, I'll rely further on my brief.
Seeing no questions, thank you.
Thank you.
Attorney McGann.
May it please the court, my name is Yael McGann and I'm representing Richard Smith as Chief of Police of the town of Wakefield. The district court did the one thing that it was not permissible to do when reviewing license to carry under GLC 140 section 131. It basically took its own preference and its own opinions and based it on the decision. The Superior Court stated correctly that under the statute, the judgment of suitability belongs to the chief of the licensing authority. The district court is limited to ensuring that the chief's discretion was exercised fairly, i.e. was arbitrary, capricious, and was not abuse of discretion. The district court never mentioned any of those words in its decision.
Can I ask you a question about that? In many of our decisions, we reach a conclusion that even though there are no express findings, that there are implicit findings in a decision in the trial court. And Mr. Tassel has suggested that, in fact, the findings, the necessary findings, were implicit in this case. Why would that be unreasonable for us to conclude?
Well, because the district court judge decided arbitrarily what is going to be an amount of time that is acceptable to give back the LTC. For instance, we do have a case which we stated, the Nichols case, where the judge stated that 5 years was not enough time in order to give back the LTC to the appellant.
As your brother counsel has observed, the extent of the involvement with drug sales in Nichols was significantly greater than demonstrated here.
It was, but still with an LTC, all that matters is public safety. And the decision is held in the hands of the chief of police. The chief of police took all the information that he gathered, information that was reliable and credible, and he made the decision that Mr. DeSisto is not a suitable person to carry an LTC at that moment. Perhaps it will change.
Would you agree that at some point a decision that that one act rendered the individual unsuitable would no longer be reasonable?
Well, it might be. It might be. We do have a case that's called Karras, which we did mention in our brief, where there was a grandfather who for many, many years held an LTC. He was a great citizen, never had a problem with the police. And yet one day he was in his car, his gun was in the glove compartment. The glove compartment was not locked. His drug dealer grandson was able to get that gun, and then he escaped, and eventually the police were able to apprehend the gun and the grandson. And yet the chief of police did conclude that even though with all the history of a good manner with an LTC, still at that moment, he was not a suitable person to hold an LTC.
Was there any error in the chief's consideration of evidence that had been suppressed in a criminal case?
I'm sorry, could you repeat that question?
Yeah, was there any error in the chief's consideration of evidence in a criminal case that had been suppressed?
No, there was not. The exclusionary rule does not apply to an LTC. As my brother was trying to claim and did it incorrectly, the amendment that happened to the statute in 2014 did not change the type of information that a chief of police is able to rely on in order to deny an LTC. It only changed that the information has to be reliable and credible. They did that in order for rumors and people with ill will not take away a person's right to an LTC. In fact, there were many cases which we did put in our brief where illegal searches were able to even though they were excluded in the criminal case, they were not excluded in an LTC evaluation of a chief of police.
But there are, as your brother has observed, some instances where they in fact can be used in employment or can be excluded in employment considerations. The Framingham case being one of those.
Well, in that case, also it was the Framingham police stopped that police officer, and they stopped him illegally, and the search was done illegal. And then the court concluded that a town cannot use something illegally and then use it in a civil proceeding. This is not the same case. The town of Wakefield did not stop DeSisto in order to revoke its LTC. It stopped DeSisto because he was under surveillance for several months for using and for dealing with drugs. And so when they followed DeSisto, they did not follow him in order to take away the LTC. They just followed him because of his previous use with illicit drugs.
Can I ask you this, though? As I understand it, I'm not necessarily troubled that the information gleaned through the CI did not result in criminal charges. But is it true that there are no police reports that were made contemporaneous with the CI investigation? Is that accurate?
Yes, unfortunately,
So
there
that's
was no
troubling, right? So police officers could get on the stand, not saying these two did, and just say, oh yes, we were working with the CI. This is what the CI said. We didn't reduce anything to writing. Nobody was charged. That's I would think that there would be a better way to document, even if it wasn't going to result in criminal charges. It's really hard to defend against something that you don't know what the accusations are.
Yeah, I mean, again, the chief of police did not back in the day. The chief of police revoked the license to carry because he was apprehended and a bag of heroin was found next to him. That was the main reason why the LTC was revoked in 2012. The informant and the testimony of the police officer, it was a shame that there were no reports. However, it does not mean that it did not happen. Still, a testimony of a police officer is reliable and credible and can be used in determination of whether a person is suitable to carry an LTC.
A short while ago, you alluded to a fairly long and extensive period of surveillance and investigation that led up to the interaction with the CI and also the stop with the bag of heroin. Is the description of that surveillance in the record?
The description of the surveillance is in the record, yes, and the district judge did hear exactly what happened. Actually, the police officer lengthily explained exactly how it happened, that he patted the CI before he made sure that the CI didn't have anything on him, did not have any.
I'm not talking about the CI controlled by itself. I'm talking about you suggested that he had been under surveillance and under review for suspicion of drug dealing for several months before that controlled by. And my question is whether that a description of that period of surveillance is part of our record.
Well, you could see that the period of surveillance when the police officer was talking about the CI was in 2011, beginning of 2011, 2012. So the police and when was asked why they actually followed DeSisto, the police officer did claim that DeSisto was one of the people that they have been following for drug use and for dealing with drugs. And so he has been.
I don't remember. Again, it may be there. I just don't remember. You had said it had been ongoing for several months, and I don't remember that description being in the transcript.
Well, perhaps the description of ongoing for several months was not mentioned, but you can see from the timeline that they followed DeSisto. In fact, the police officer said that it happened more than once. And so it was a fraction of timeline. And then obviously when they followed DeSisto back in 2012, the reason why they followed DeSisto was because he has been under surveillance by the police officer of Wakefield.
I also
Go
can I
ahead.
just one question about the motion to suppress, which is, I appreciate the argument that the exclusionary rule doesn't apply, but unlike many criminal cases that we see, if I understand the record correctly, the motion was allowed by agreement of the Commonwealth. And that's very different from what we typically see. That suggests to me the Commonwealth knew it couldn't meet its burden. That has some significance to me. What do you think? Do you agree that that has some significance? And either way, how should we consider that information?
Well, it might have significance, but I don't think it should change the outcome of the fact that the chief of police did have the right to consider that information. In fact, the DeSisto enjoyed already the exclusionary rule in the fact that criminal cases were not brought forward against him. He cannot enjoy that twice. In fact, a chief of police is not only that does not only have the permission to use all kind of evidence, but he has he must use, he is directed to use all of the evidence, all the credible and reliable evidence that a chief of police has in his or her hand in order to ensure that only suitable people will carry LTC. And so the exclusionary rule does not apply in this case to the chief of police to making those kind of decisions.
You mentioned that in addition to evidence of drug dealing, there was evidence of the applicant's use of controlled substances. Other than the statement by the witness that he was buying drugs for Mr. DeSisto because he was drug sick, quote, was there other evidence of use?
No, Justice Kender, there was not.
So the evidence of use was limited to that one comment.
Yes, was limited to that one comment, as well as the police finding that one bag of heroin next to him after they stopped him, after the car was stopped by the police. And the fact that he was dealing several times, at least more than once, with Percocets. Are there any other questions?
I see none.
Okay. Well, I just wanted to just to say that the district court did abuse its discretion. It did not, not even once did it say that the chief justice, that the chief of police did not act fairly or did not acted arbitrarily, capriciously, or abused of discretion. In fact, it just said that if she was the chief of police, she would have acted differently. That is not the way to decide in these types of cases. That is not the judicial review for these type of cases. I do want to say one more thing. In an LTC, if a person lies on an LTC, that is a ground to deny a license to carry to that person. Nonetheless, if he lies on the bench, if he lies in a judicial procedure, that is also a reason to deny an LTC. So,
Ms. Morgan, that of course has some logic to it, but can you cite any authority to us for that proposition?
Well, there are different cases that we cited, such as Callaway versus chief of police of Quincy, Catucci versus Vendetti, where they lied and they were not allowed to receive an LTC, and also on the forms of an LTC. You need to sign it under under the penalties of perjury, and it does state that if you do lie, you will not be able to, you will be denied an LTC.
The authorities that you include in your brief are all unpublished. Do you have anything that's published and therefore binding as precedent?
I can't find it right now, Your Honor, in my notes. I do have Costeras in 2001. He did fail to disclose evidence from domestic abuse charges.
Right, that's a Superior Court decision, as was the Catucci and Benedetti, and then there's an unpublished decision by the appeals court.
Perhaps I can maybe submit. I do think that we do have a case where we cited. I just can't find that in.
We have your brief. If you have one that's in your brief, we'll look at that. Thank you. Ready to go.
Live and on the record.
Thank you. Our next case on the list for hearing this morning is case number 2020 P819, James Z. Dakin versus OSI Restaurant Partners, LLC, and others. Mr. Charnas, you may begin.
Thank you, Your Honor. May it please the court, my name is Scott Charnas, and I represent the appellant in this case, James Dakin. The issue of joint venture should not have been submitted to the jury in this case. There was insufficient evidence as a matter of law for a reasonable jury to find joint venture under the Shane-Gurry factors. I'd like to go over those factors and look at the evidence or lack thereof. So first is the agreement to manifesting an intent to associate for purposes of joint profit and sharing of losses. There was absolutely no evidence that such a circumstance existed. In fact, the uncontroverted evidence was that the opposite existed. There were two operating agreements which controlled the relationships between the three corporations involved here. And both operating agreements made it clear that any profit or losses from OS Restaurant Services were to be allocated to Outback Steakhouse of Florida, and any profit or losses from Outback Steakhouse of Florida were to be allocated to OSI Restaurant Partners. So
Mr.
there was.
Charnas, if I could just interrupt you.
Yes.
I know that you're from New York, so I'm assuming that you are familiar with cases around the country, and Bloomin' Brands is a significantly large company or brand with its parent and sub. Are you aware of any cases involving this corporate structure across the country that have held what you're asking us to hold?
Judge, the cases that I have read involve other theories for employees of Bloomin' Brands or those corporations to be held to have, for those corporations to have workers' comp immunity. I have not found another case where joint venture was the theory.
Okay.
The underlying question is the degree of affiliation and joint enterprise, and whether it's labeled under the obviously across the 50 states, there will be different frameworks under the respective workers' compensation statutes, but the underlying principles that animate each of those tend to converge. It's a bit of a stretch, I will confess, for me to accept the proposition that the local franchisee in an operation like this is not closely enough affiliated with the franchising national franchising enterprise to treat them as being joint venturers for purposes of carrying out their business.
Well, I think the issue is, what are the profits? How are the profits allocated between these three companies?
That's one consideration.
Well, yes, I'm just talking about this factor, Judge.
Yeah.
But they're not only, it's not a matter of conjecture. No profit from Outback of Florida, which owns and operates this particular restaurant and other restaurants, is held by Outback of Florida. It's simply a pass-through to OSI. That's the way they've set it up. So it's not a matter of what's hard to believe or not hard to believe. Those are the facts. So you would not invest as an outside person in Outback of Florida because you would never see a profit. I think that's the bottom line in that regard.
You rely in your brief fairly significantly on the Gurry case. I guess my reading of the Gurry case suggests that it rested on a significantly different set of considerations. You had two separate branches of a corporate predecessor tree that were merged, and the court was concerned about the happenstance that liability would be lost by the coincidence of that merger and resulting successor liability. That's not what we have here. What we have here is a joint enterprise that from its inception involved both entities.
Well, Your Honor, the Gurry case deals with two general issues. One is what you're talking about, but the issue of joint venture was completely separate from the issue of joint employment, for example, and things of that nature. So there is a separate discussion of joint venture in the Gurry case, and I think that does in fact apply here, and that's supported by the Shane case. And also
with our decision that happens to be authored by our Chief Justice, Sullivan versus Lawless. It was in the context of a property dispute, but addressed the question of partnership, and it's the most recent case I could find that further amplified Gurry Shane. Are you familiar with that case?
I confess I'm not, Judge.
Okay.
But
2018 case.
I think that all these, I don't think that any court in this Commonwealth, appellate court in this Commonwealth, has found a joint venture where there is no intent to associate for joint profit.
Let me turn your argument around and look at it from the other direction, if I may, just for a moment, and ask you for just in broad strokes, what's the end game here? If these two entities are really as disconnected as you suggest, how would there be a theory that would support a recovery from Outback of Florida?
Well, you mean in a tort recovery, Judge?
Yes.
Well, first of all, they're not disconnected. They are very closely intertwined. And I think the lower court made the mistake of confusing the concept of mutual benefit. They're certainly intertwined for purposes of mutual benefit. So I don't say that these corporations are completely separate. I say they're intertwined for mutual benefit, but they're not joint ventures under the Shane Gurry characteristics or factors. And in terms of the tort liability, I mean, I'm getting far afield from the evidence that was submitted in this case, but essentially we're going to show, if we get this opportunity, that OSI set up a system for inspection of kitchen equipment, which never was promulgated, and they knew it was never promulgated. And also, OSI set up a system of compensation whereby the managers of the restaurant would have money spent for maintenance taken out of their own pocket in the form of lessened profit.
But all of those considerations, it seems to me, necessarily bear on the level of joint involvement in a common enterprise that take us right back to joint venture.
Well, I think it takes us right back to parent subsidiary, Judge. I think that what we have here is a classic parent subsidiary situation where the corporations are working jointly together for a mutual purpose. But that's not enough to make it a joint venture.
But is the intent to associate a question of fact or a question of law?
I'm sorry, Judge, I didn't hear you.
I'm sorry. Is the question of intent to associate a question of fact or a question of law?
I think it's a question of fact, but there's uncontroverted evidence.
So then why wouldn't it go to the jury? You said it should have even gone to the jury.
Because there was I'm sorry, Judge, I didn't mean to interrupt.
No, I assume you're going to say because there was insufficient evidence.
There was uncontroverted evidence that these corporations, the operating agreements sent all joint profit and all shared losses to OSI. So there was no evidence submitted that that was not the case.
But the factors that you're citing are an amalgam of factors. There's no suggestion that each of them must be present in order to support the finding of a joint venture.
Yes, Your Honor. And if I may be allowed to proceed, I will
Please.
show that that 7 of the 8 factors are not only not present, but the opposite is true as a matter of law. And the last factor is common to parent subsidiary situations. So the 4 of the 8 Gurry factors involve sharing joint profit and or sharing losses. So
Well, wait a minute. I mean, let's run through. I mean, we've got joint profit, contribution of money, property, effort, knowledge, skill, or other assets to a common undertaking.
yes.
You're saying that's not present here?
No, that's the one that is present, Judge, but
Okay.
that's common. That is common to parent subsidiary situations.
Okay.
The
Joint,
other,
joint property interest,
yes, I could. You want me to address
Please.
that, Judge?
please.
Yes. So the management clauses in each of the operating agreements gave complete control, unfettered control to OSI. In other words, the one operating agreement allowed Outback of Florida to completely control OSRS, that's OS Restaurant Services, and the other agreement allowed OSI to completely control, unfettered, totally their discretion, Outback of Florida. So in essence, any property interest that Outback of Florida had or OSI had was completely ephemeral because OSI at any time for any reason or no reason at all could take any property it wanted. So that's not a classic joint venture. That's not 2 companies or 3 companies who have a mutual property interest in the venture. It was all OSI. That's the way it was designed.
Right to participate in the control or management of the enterprise? I mean,
Say-
when you responded to my question about theory of tort liability, you described to me a level of control, which would be the basis on which you would suggest liability could be found.
Well, I think that there are, I think OSI is negligent in its own right for setting up this circumstance. OSI is the one that controls. OSI,
If they set up and control that arrangement, then that factor, it seems to me, would at least allow a rational jury to conclude that factor is satisfied for purposes of joint venture.
Respectfully, I disagree, Judge, because all the control was vested in OSI. So that's consistent with my theory that OSI controlled everything. So that's not a mutual right to control. It's OSI controlling.
Do you have your brief? Could you turn to page 25 of your brief where you outlined the 7 points? You pulled them out of the judge's findings, which was very helpful. Do you believe that any of these 7 findings are clearly erroneous?
It's not that they're clearly erroneous.
No, I'm getting there. I'm working my way up. So none of these 7 are clearly erroneous, right?
I don't think that any of his findings are clearly erroneous.
Okay.
Number
So the
7.
next question is, you don't believe that these 7, if we accept them all as grounded in the evidence, find ample support in the record, these 7 factors are insufficient under Shane Gurry, is what you're saying.
I just want to clarify. I was about to say number 7 is incorrect in the sense that he's confusing mutual benefit with profit. So other than that, yes, what the judge did, and I think what the jury did, is consider that the intertwining of functions was of mutual benefit to all 3 companies, and therefore it's a joint venture. But the factors that the judge found don't match up with the Shane Gurry factors.
Okay.
And they're true of any parent subsidiary relationship.
So these 7 findings demonstrate a corporate relationship, but not a joint venture.
Yes, Judge, and they don't match up to the Shane Gurry factors. There's one point, I see my time is eroding. I did want to make one point. There is which very frankly was not made in my brief, but I want to bring it to the court's attention. There's a liability of the member section in each of these operating agreements. It's section 20 in the OSI Outback agreement, and it's section 19 in the Outback Florida OSRS agreement. And basically what that says is that Outback of Florida is not responsible for any of the liabilities or obligations of OSRS. And it says that OSI is not responsible for any of the liabilities and obligations of Outback of Florida. So what this means in a practical sense is here, the parties are holding Mr. Dakin closely as an employee. He's an employee of all of us because we're all in a joint venture. But they didn't intend this joint venture, because if Mr. Dakin went out and ran into a school bus when he was in furtherance of the business of Outback Steakhouse, they would not be liable as a joint venture for that tort, for that liability. So I think this is more evidence. And again, that operating agreement was in front of the court and the jury. So they never intended this as a joint venture. This is all looking back. They don't meet the Shane-Gurry requirements or factors. And this is an example of the corporation trying to take advantage of the different corporations for their business purposes. But when it comes to being a liable in tort, they want to make it all one big happy joint venture, and it's not, as a matter of law.
Thank you. Attorney Callanan?
You're still on mute.
Hear me now?
Yes.
Sorry about that. May it please the court, the question of joint venture under Massachusetts law, that there is no comprehensive definition of the concept. The SJC and
We lost Attorney Charnas.
No, we just lost his video.
Oh,
He's
okay.
here. He's on mute, but that's okay.
I'm sorry, Mr. Callanan.
It's okay. The concept of joint venture, as it's defined in the Massachusetts case law, there is no comprehensive definition. And the decisions have repeatedly said that. The clearest articulation of what a joint venture is under Massachusetts law comes from the SJC in the Gurry case. And they say the key element is an intent to associate. The Gurry case then points to the Shane case for the indicia of an intent to associate. And this court in the Shane case said the same thing. There is no comprehensive definition, but they provided a pragmatic checklist of considerations, which if present or absent, may bear on the recognition of a joint venture. So again—
Are you aware of any cases across the country in which this corporate structure has been challenged in some sort of a workers' comp dispute, understanding that every state has different statutes and different cases, and how have those cases resolved?
I'm not aware of any other cases involving the question of joint venture in other states. And I suppose I would think that it would depend on state to state. And in this trial, the issue was joint venture as Massachusetts defines it. Both parties moved for summary judgment. Judge Pasquale denied the motion finding a fact issue. The Gurry case said it was a fact issue because it's intent. It's what do the parties intend, and intent is more often than not an issue for the jury. The Shane case provides the pragmatic checklist of considerations, but the Shane decision doesn't create any minimum requirements. It doesn't create any formula. It gives a checklist of factors that, if present or absent, may bear on the existence of a joint venture.
All right, so give us the checklist. Which factors were present?
Sure. So the first factor is an agreement by the parties manifesting their intent to associate for joint profit, not amounting to a partnership or a corporation. This jury saw 4 contracts, 4 agreements, 2 operating agreements, the master employment services agreement, and the employment agreement of the manager of the Hanover Outback store where Mr. Dakin worked and was injured. Each of those agreements manifested an intent to associate.
So your brother says that those agreements are evidence of a corporate structure, but not necessarily a joint venture. How do we get from corporate structure to joint venture?
Because the agreements, including the operating agreements, manifest an intent to associate for the common undertaking of operating 4 themed restaurants. Each of the companies fit together in an interdependent way to manage this business. OSI owns the 4 different brands. Outback Florida owns Outback Steakhouse and all of the Outback Steakhouse assets. Outback OSRS, the one entity that the plaintiff believes is entitled to the workers' comp bar, provided employees to the restaurant entities. And it did so in exchange for a fee, and it did so with the agreement that it would not provide employees outside of the system. So the agreements create a closed system where OSRS provides employees, restaurant level employees, to the different restaurant brands. In exchange, the restaurant brands pay a fee to OS Restaurant Services to provide those employees.
What do you mean by a closed system?
A closed system meaning OSRS, the entity that provides the employees, it doesn't provide employees to McDonald's or Burger King or
Walmart.
Right. It's all within one system for the common undertaking of running these restaurants.
What you're describing sounds like at least something a rational jury could conclude is a wholly interdependent enterprise where separate entities discharge discrete functions, but the enterprise cannot be conducted without the participation of all 3.
Correct. And the jury also heard testimony from Celeste Perino, an attorney employed by OS Management, another entity within the system. And she described to the jury that the purpose for all of this was to create efficiency and consistency towards the goal of profitability.
Mr. Callan, in your view, can you have a parent subsidiary corporate relationship that is not a joint venture?
I suppose you could if it somehow didn't meet the factors set forth in Shane. In other words, I don't read the case law either in Gurry or Shane or the related cases to make corporate structure a factor. And in the Gurry case, it was related subsidiaries of Cumberland Farms. So as the factors are set out and as the Gurry case reads, at least the way I read it, it's what is the intent of the parties, and then following through those factors, whether the factors are present.
So you agree with Mr. Charnas insofar as it's possible to have a parent subsidiary relationship that is not a joint venture, but you disagree as to the application of the factors.
Saw the 2 operating agreements. I'm sorry, did I cut out?
You did, you froze.
Did I finish answering your question?
I'm not sure.
Okay, let me try it again. What I said, if I recall what I said correctly, I don't read Gurry or Shane to make corporate structure either an indicator for or against. Gurry and Shane, as I read them, make the intent to associate, and then the factors listed in Shane. And in Gurry, they were 2 subsidiaries of the same common parent. So I'm not sure corporate parent subsidiary is relevant the way Massachusetts looks at joint venture. So continuing on with the other agreements that manifested an intent to associate, in addition to the 2 operating agreements that intertwined the entities, and the way the entities were intertwined, OSI was the member of Outback Florida. Outback Florida, in turn, was the manager of OS Restaurant Services. So it's not as though OSI owned both of these entities. OSI was the member of Outback Florida. Outback Florida, in turn, was the member of OSRS. Outback Florida was created with an initial $100 from OSI, and future capital could be delivered to it from OSI. In turn, OSI would get any distributions, and Outback Florida's profits and losses were allocated to OSI. In turn, Outback Florida initiated OS Restaurant with the initial capital.
Can you go through the profit flow? Because your brother spends a great deal of time in his brief
Right.
On that profit and loss issue.
Right. So each of the two operating agreements allocate profit and losses. So OS Restaurant allocates its profit and losses to Outback Florida. Outback Florida allocates its profits and losses to OSI. OSRS only generates revenue by providing employees to Outback Florida and other OSI restaurants. So for the first way they share in profit is by the interaction that's created by these agreements. The only way OSRS makes money is by providing employees to Outback Florida and other OSI controlled entities. And then they
And
get
you've described that as a lease of the employees. So other than that, the payment for leasing employees, does OSRS share in any of the net profits of the parent?
No, OSRS, if it profits or if it has a loss, that is then allocated to Outback Florida. Outback Florida owns all of Outback Steakhouse. So the way they share in profits and losses is that each entity's profit or loss could affect the other. If you didn't have that you didn't have that structure, that wouldn't happen because they're separate entities. So if OSRS profits or has a loss, that can affect Outback Florida. If Outback Florida has a profit or a loss, that can affect OSI. So there's interaction that you wouldn't otherwise have without that requirement of the allocation of profits and losses. So I believe there was evidence upon which the jury could have found or reasonably inferred that there was sharing of profits and losses given their interaction and given that requirement of allocating profits and losses. So I believe that was, that's factor 5. So just working my way through the factors, I believe my brother doesn't dispute that there was evidence of factor 2, contribution of money, property, effort, knowledge, skill, or other assets to a common undertaking. So I'll pass over that. Factor 3 is a joint property interest in all or parts of the subject matter of the venture. As I just mentioned, that the operating agreements create a joint property interest because Outback Florida was created with capital from OSI. OSRS was created with capital from Outback Florida. Each parent has the exclusive right to declare and keep distributions from each subsidiary. And separate from the structure, OSI is the parent of the 4 different restaurant brands. Outback Florida owns all the Outback assets. So that's leases, intellectual property, kitchen equipment, including the equipment that Mr. Dakin was injured on. Outback, OSI and Outback share that interest because OSI is the manager of Outback Florida. And again, the agreement between OSRS and Outback Florida to provide employees creates a joint property interest because without employees, these restaurants can't run. So not only does OSRS rely on the restaurants for a place to send its employees, but the restaurants need OSRS's employees. The 4th category is a right to participate in the control or management. We've touched on this with regard to the operating agreements. The jury also saw Exhibit 6 and Exhibit 7, which were the employee policies. And Mr. Dakin, who was a Outback Steakhouse kitchen employee, he was subject to employment policies issued by OSI and by Outback Florida.
I know that you're in the middle of your list, but based on your time, could you look at volume 1 at record 70, which is the org chart? I just want to go through a couple of those bubbles with you.
Sure.
I guess my first question is, under the parent of Bloomin' Brands, do we have to concern ourselves at all with the OSI holding companies?
No, the relevant entities in this case are OSI Restaurant Partners, which is in the green level.
Yep.
And then just to the left of that, you'll see Outback Steakhouse of Florida, a Florida limited liability company.
Right.
And then below that is OS Restaurant Services.
And that's the OSRS.
Right.
Okay,
And-
thank you. I'm sorry to interrupt you. I just want to make sure I understood the chart.
Sure. Without trying to rush through the rest of the factors, I'll rely on what was in my brief. But at the end of the day, the jury was correctly instructed. The question is a question of fact because it relates to intent. And there was sufficient evidence on which the jury could have found the factors based on the law, because the law doesn't create a particular formula or equation or minimum requirement. And there was enough evidence presented to the jury to satisfy all of the Shane factors. And really what plaintiff is asking this court to do is to replace its judgment for this jury's judgment. And there isn't any basis to do so on this evidence with this type of issue when they were correctly instructed and they received sufficient evidence. So with that, I will stop unless there's any other questions.
See none. Thank you. Thank you both, and others.
Good morning, Your Honors. May it please the court. My name is Mark Dickinson. I represent Mark and Catherine Ransom. The Ransoms owned property in Winchendon, Massachusetts. They had 2 lots. In 2013, they contemplated building a large barn in a pasture on one of their lots and wanted to clear some trees and do some site work to make that happen. They hired a general contractor named Robert Hakala, who in turn hired or subcontracted the defendant appellee GTL. And GTL then subcontracted further to have a company called S&K help clear the land. Now, my client, Mr. Ransom and his wife, they basically wanted to clear their land to build this barn and pasture, but they wanted to maintain their privacy and essentially the integrity of the property in the sense of having a 10-foot buffer of trees. The property, the lots had essentially had a lot of mature trees of red oak, white pine, and hemlock on the property. And Mr. Ransom gave explicit instructions to Mr. Hakala that he wanted a 10-foot buffer along the adjoining property, the property boundaries. And it's undisputed that he gave that instruction. In fact, the Superior Court found that that instruction had been made, and Mr. Hakala, for whatever reason, when he gave his instructions to GTL, essentially never walked the property, never staked the property. There was some evidence the property had been staked along the property line from prior surveyors, but they never particularly marked the 10-foot buffer area.
Let me just stop you there because we're familiar, as I said, with the factual background. And your claim is for trespass against trees. And in the arrangement that you've just described, GTL was not merely under a license; they were under a contract, subcontract with Hakala to perform this work. They performed the work in a manner that was consistent with the instructions that they received from Hakala.
Well, I think that was disputed. I think that essentially the instruction had been made, and Mr. Hakala said this, that there was supposed to be a 10-foot buffer. And whatever reason, frankly, by mistake or negligence, that instruction was not carried out. And so the trees
But
were,
the- but
there's a massive
point,
over.
the point is that for trespass against trees, the person who is held liable in trespass must act without authority to do so, and must know that they were without authority. And
Yeah,
here they operated under license or direction by Hakala. They absolutely believe that they were permitted to do the work that they performed.
I don't disagree with that, Your Honor, in the sense that they meaning GTL thought they had license. Well, you know, it's the issue here is that they were, you know, clearly on the property with permission to do cutting. There's no dispute about that. The question is that they, you know, Mr. Ransom had only allowed or only directed GTL, and there was evidence, by the way, that he directed Hakala rather, but he overheard Hakala talking to the principal of GTL and giving that repeat instruction. There's evidence in the record. There's an email that Mr. Hakala said that was the instruction, to keep a 10-foot buffer.
Well, but I mean, those get to be questions of fact, right?
Right, those are questions of fact. But the ultimate issue here, Your Honor, is that there was no license given by the property owner to clear cut the 10-foot buffer area.
No, but the person that you are seeking to hold liable did receive instruction from someone that they understood to be authorized to give that instruction as agent for the property owner. And if there was a gap in or miscommunication in that level of instruction, you know, I could understand where you may be able to move against Hakala for failure to convey the instructions adequately. But it's hard for me to understand how GTL can be held liable in trespass where they were acting under the authority conveyed by the owner's agent.
Well, you know, I dispute that there's really an agency relationship here. I think that's my brother's big argument here, is that, you know, Hakala is somehow Ransom's agent. I mean,
when Hakala undertakes by contract the obligation to perform the work and then subcontracts it, he is in that regard passing along the instructions of the principal in the contract.
Right. Well, I would think of it a little differently, Your Honor, which is that, you know, Mr. Ransom gave a limited license in a sense. He gave a license to cut the trees, but it was limited to this, you know, to stay away from that 10-foot buffer area. And that was the mandate given to, in the contract essentially entered into with Mr. Hakala.
Once again, I mean, I can readily understand how that might give rise to liability against Hakala for violating by authorizing someone to come in. But I have a very hard time understanding how someone who in good faith acts pursuant to the instructions of their contracting entity under subcontract with the owner can be held liable in trespass against trees.
No, I understand, Your Honor. I think our best case on this that speaks to this issue is the Evans versus Mayor Tree case from this court. This had to do with, you know, I would say even a more you know, sympathetic situation for the tree cutter, where Marquee Tree Company was hired by the state to essentially subcontracted because there was an Asian longhorned beetle infestation of Worcester. He had a federal official standing right next to him who directed him to cut certain trees, and there was a mistake made. And the court in that case basically said, look, you know, this liability is under this trespass to tree statutes. It's not based on fault. It's based on whether there was, you know, license. And in that case, they found that, you know, a mistake about where the cutting area was or which trees were to be cut required remanding it back to a superior court. And I think this case is a lot like that case, you know, and the statute's pretty severe. It basically says it's without fault, and the question is of license. And it's clear, at least from our perspective, is the landowner gave a direction you know, we explicitly said, and there's an admission in the record by the contractor that he got that instruction, a 10-foot buffer, and the fact that his subcontractors made a mistake, you know, that's, you know, they didn't have license to do it. Their only possible license could flow from us. So I think we're, you know, we may disagree, Your Honor, as to the outcome, and that would be bad for my clients. But you know, I think that's our best argument with respect to the why GTL is liable.
Let me move you, because I see we're moving through the time here, to the question of damages.
Sure.
There are various alternative means to measure the damages, and they can, of course, in various circumstances, lead to strikingly disparate outcomes, as they would in this case.
Right.
Why do you suggest that that an award of damages far in excess of the value of the property taken as a whole would be the appropriate measure of damages in this case?
I think it's the only remedy available, Your Honor, in the particulars of this case. You know, the case law is basically pretty clear. You know, obviously the statute's silent as to what damages is. And so we've got this pretty well-developed case law. And, you know, essentially the case law is that if you're, you know, if the value of the timber is negligible, which it frankly was in this case, I don't think that's really in dispute. And then there's no diminution of property value. I mean, you know, the property there in Winchendon, it's across from a state park. You know, frankly, you really, it's really personal to the ransoms, in the sense that their privacy was lost. It's a violation of their rights.
Who makes the decision about what measure of damages to apply?
The Superior Court judge does, and
what standard do we apply in?
It's a great question, Your Honor. You know, I would argue it's a de novo standard, because it's really a question of the appropriate law. I think I've read some cases, obviously in preparation for today, where you know, it's essentially more of a abuse of discretion standard, because, you know,
I would say that, you know, ordinarily in a question like this, I would expect it to be abuse of discretion. These sorts of things generally are, and,
right.
And the considerations that would bear on that would include how best to compensate the owner for the objectively reasonable loss that they incurred with money damages. Diminution in the value of the property would, in fact, be a close counterpart for that, as would the value of the benefit obtained. But you know, subjective sense of loss of privacy would ordinarily be a difficult criteria for the law to enforce.
True. But you know, I think we do prevail under an abuse of discretion standard, and the reason why is because, you know, the trial judge characterized this as a slight injury, and really made no finding. You know, even though the record was replete with evidence of the extent of the cut. You know, that's really what we're talking about here.
About the trees being of inferior quality, right? On that point, I know your expert testified that it was somewhere north of 390,000. There's something in the judge's decision, 863,000. Do you know where that number comes from?
Yeah, that comes, you know, we're not here to advocate, but basically my client also went to another landscape. He basically went to a landscape, like a Mahoney's or somewhere, and said, if I had to buy like 10,000 trees, what would it cost? And it came out with an enormous number. So that, you know, that's in the record. You know, that's clearly that there was no cost to restoration analysis. And so getting back to the point, Your Honor, Justice Green was raising, you know, I think there's an abuse of discretion here, because in the facts and circumstances of this case, there was really no alternative to award proper damages for the injury involved. There's no, the timber, value of the timber was just negligible. There's no real diminution in the property value. The harm here was the extent of the overcut. There was 16,000 square feet overcut. It were trees that are going to take, you know, decades to grow back. And the judge completely ignored what a very qualified expert, Ellis Allen. And I think that really the judge abused her discretion in terms of finding that this was a very slight injury. And really in this type of case, the facts mandated using a restorative number. Now, whether, I'm not asking this court to just adopt Ellis Allen's testimony and award $390,000. I think it requires remand. And I understand that this is not
Mr.
the most.
Dickinson, can I interrupt for just
Sure.
a moment because your time is short? But assuming for purposes of this question that the judge concluded that $390,000 would be an unreasonable windfall in this case,
Right.
why couldn't the judge consider that fact in her selection of a measurement of damages?
Because by completely rejecting the restoration, then it doesn't leave any compensation for, essentially the fact that you're going to have, and this is really
The absence of compensation is a product of the fact that the other applicable measures of damage in the facts of this case demonstrate no significant loss.
Yeah, but there really is a loss in the sense that again, it was a very grave overcut. 16,000 square feet, significant. It's a loss of privacy. It's a special purpose kind of situation where the court has talked about using in the Trinity Church case. You have a nonprofit. How do you how do you restore? I think it's a difficult question, but I think it was.
Would it land in Winchendon? It seems to me is less iconic than Trinity Church.
I would have to concede that, right? And Your Honors, I think that unfortunately, I think the judge did make an abuse of discretion in rejecting, essentially the restoration, and it should be remanded to allow the court to take that factors into account and award appropriate relief. Thank you very much.
Thank you. Attorney Dombrowski, if you unmute yourself and present argument for GTL.
Good morning, Your Honors. May it please the court, John Dombrowski, on behalf of the defendant appellee.
I'd like to encourage you to begin your argument by addressing your brother's contention that Evans, from this court, Judge Mielke's opinion of a few years ago, negates your suggestion that the GTL is absolved of liability by receiving authorization from Hakala.
Yes, Your Honor. The Beetle case, Your Honor, the facts of that case are markedly different. If a federal agent it certainly has some authority, but is not an agent of the owner. In this particular case, Hakala is a general contractor. In case law that I've cited in my brief, holds that a general contractor is an agent of the owner. And I think you have to bring that against the court's specific finding that the instructions given by Hakala to Lippozan were the only instructions that Lippozan received. And I'd further emphasize to the court, I think it's important to look at the topography of this particular property. There are two lots. They're both have 200 feet of frontage and both contain 12 acres. There's a steep incline, and this is found by the trial court. There's a steep incline from the street through wetlands. Then there's a plateau-like area on both lots, and then it drops off again. And then there's a neighbor on the right that has a fence. And the Hakala's instructions to my client were to clear the flat elevated area of each lot and halfway down the slope from the plateau to avoid the wetlands, and to stay within 10 feet from the neighbor's property on the right, which was marked by the fence. And that was essentially exactly what was done here in the court so found. So I think the fact that Hakala was found to be the general contractor is the only person that my client engaged with whatsoever, only received instructions from Hakala and followed those instructions to a T. I think that takes it out of the ambit of an authority figure giving mistaken advice or instructions to a contractor.
And on measure of damages?
Measure of damages, Your Honor, I think the trial court was troubled, or it seems to be troubled by the fact that what was the overcut? Ransom is the only one who communicated with Alan, and initially he called Alan in, and there was a certain area that was defined as a supposed overcut. And then Ransom calls him back several months later because suddenly there's more overcut. Practically speaking, I'm not quite sure how that happens in these circumstances. So you have overcut A, you have overcut B. Hakala testified.
But that goes to a dispute of fact that the trier of fact is well equipped to resolve. It doesn't bear on the appropriate selection of the measure of damages.
I don't disagree with that, Your Honor. But again, if you're going to go with the restoration cost of damages, there needs to be a determination of exactly what was the overcut.
Oh, right, but that's the task of the trier of fact, and you have to determine the scale of you'd have to do the same thing whether you use the value of the cut wood.
Absolutely, but again, in this case, as the court found, the court did not find that there were any privacy issues. Again, you're talking a very low value quality of wood. There were only 14 cords of wood, as the court found, taken off the property, which suggests a smaller area. And again, this is not pristine property. This is not a situation where a view is at risk, or like the cases that are cited where we're talking about ocean views, things of that nature. And again, I don't think you can ignore the economics of it. I don't think you can ignore the fact that one lot costs $25,000, another lot costs $70,000, and we're talking an exorbitant amount of money to restore, to go that route of restoration.
But you don't deny that the value of the lots would not bear, for example, if there was an ornamental garden that consisted of rare breeds of Japanese maple that had been planted there as part of an overall landscaping theme. The landowner in that circumstance would be entitled to recovery of the specific trees that they had planted for decorative purposes, right?
I don't know, Your Honor. I think that's a far different scenario than the case at bar. And again, these are difficult lots. Going back to just the facts of this case, the court made very specific findings, and I don't believe that the standard that the trial court was clearly erroneous has been satisfied in this matter, particularly with the instructions given to my client and followed by my client. And I think that it really centers on that.
Is there anything further that you'd like us to consider beyond what you have in your brief?
No, I think what's covered in my brief and what's covered in the court's ruling is sufficient unless the panel has any other questions.
Seeing none, thank you both. We will be in recess and resume our hearing list with the next case at 11.
Justices, good morning. Mark Carchidi on behalf of Mary Ann Poulos. The facts of this case suggest, Your Honor, that Mary Ann Poulos would be entitled to the relief that we are requesting, which is a remand, vacating rather, of the summary judgment and the declaratory judgment entered by the trial court, the probate court. And in furtherance of that, Your Honor, I would suggest that you have the ability to do that by application of both the law and equity. Mary Ann Poulos is the daughter of Peter Poulos, and cutting to the fine points, Your Honor, the gravamen of the trial court's decision in granting the summary judgment, which this court is reviewing by way of a de novo review, is that the trial court and Peter Poulos' reliance upon the fact that redemption, the application of the doctrine of redemption by extinction to an irrevocable trust is unfounded both in the law, under the statutory law, and under common law. And the
Can I ask you a question about that, Mr.
Yes,
Carchidi? You cited Wasserman, as I understood it, in support of your argument that redemption by extinction should not apply in the circumstance of an irrevocable trust. I didn't read Wasserman to go quite that far. Perhaps you can enlighten me on that.
Sure, Your Honor. First of all, the appellee relies on Wasserman, and I would suggest that the fundamental distinction in Wasserman, Kelly, and those lines of cases is the fact that those lines of cases involve irrevocable trust. And in circumstances where there was a testator that was involved with a will, and the challenges that were made were by beneficiaries under a will. The significant distinction in this case, Your Honor, is that there is no estate plan. That is a fundamental distinction. There is no will, and what the appellee is seeking, and what the court did, was they applied the facts to find that this was in fact the series of documents which consist of the two declarations of trust and the original deed constituted a will substitute. And I point to page 229, Your Honor, which is this, I believe it's the fourth page of the summary judgment. And the court itself there finds in that very first sentence in the second paragraph, but that in fact that the cases involved, that this case involved property that was intended to be disposed of by a will or a trust in the context of a estate plan. That's how the trial court itself referenced and relied on Wasserman. And
I'm sorry to interrupt, but I want to, and I'm sorry to Justice Kinder if I've interrupted before he was able to adequately answer your question. But I just you referred to the will, the terminology of a will substitute, and I have to say I'm not familiar with that in the law of probate. Is that a term of art, and do we, in circumstances as in application of the law, in certain circumstances, apply testamentary doctrines to documents of transfer that or documents of title that otherwise are not wills because they are fairly viewed as constituting a will substitute?
I would suggest, Your Honor, that the use of the term will substitute is really a legal fiction, especially in this case. I would also suggest, Your Honor, that I have found, and the appellee has not cited either statutorily or any common law precedent for the application of an irrevocable trust to any will substitute.
But on that very point, there doesn't seem to be any authority cited by either one of you that stands for the contrary proposition.
There isn't, Your Honor, and I would suggest that this really is a case of first impression, except for the fact that under the statutory provisions of both the Massachusetts Uniform Trust Code and the Massachusetts Uniform Probate Code, there appears to be a clear example of the intended distinction between an irrevocable trust and a revocable trust. At its very basic level, Your Honor, I would suggest if there was no distinction between an irrevocable trust and a revocable trust, then all the years of precedent, both in common law and statutorily in terms of drafting, would be for naught. And the courts would not have spent all this time over these many years distinguishing it.
Mr. Carchidi, I want to go back, I guess, to first principles, because I've been at this a number of years, but I will confess that I have not wrestled with the doctrine of redemption very often. What is the purpose of the doctrine of redemption? Why was it established, and what is it designed to achieve?
The purpose of the doctrine of redemption by extinction, Your Honor, and that's important, was developed to recognize that in an estate plan or a testamentary plan of some kind, that if the item that was provided for and disposed of by way of devise to the benefit to the devisees, if it was disposed of by action of the testator during the testator's life, which is a significant importance, that if it was disposed of during that time and it no longer existed, then that devise would fall by the wayside.
Now, I suppose that question arises for the first time when a court is faced with the question of how to deal with a document that directs the transfer of a particular property that no longer exists. And the testator has died, and there's no way to sort out what to do about that situation.
I think the significant distinction in this case, Your Honor, in these set of facts is the reason it does not exist is because of the actions of the land court ordering the commissioner's sale. There were no actions taken by the testator in the approximately 30 years from 1987 when the trust was created and the deed of transfer was recorded.
Yes, but Mr. Carchidi, with all due respect, if that same circumstance had occurred during the testator's lifetime, and this property had been the subject of a specific bequest in a will, the doctrine of redemption would plainly apply, correct?
If I understand Your Honor's question, you mean if it had been part of a consistent estate plan?
Let me put it into specific terms. The testator puts the property as a specific bequest in his will. Says Blackacre will go to my daughter Anna, and then while the testator remains alive, the land court issues a judgment of tax foreclosure, decree of tax foreclosure, excuse me, and the property is sold at a forced tax sale. And now Anna is in the probate court seeking her bequest. The doctrine of redemption would by extinction would plainly apply, right?
Yes, it would apply. I would suggest, Your Honor, except there are two cases, the Walsh and the Bostwick cases, which indicate, and the court has decided that there are two exceptions. The exceptions would be, and those were applied to revocable trusts. Now, again, this is a case of an irrevocable trust, and I would suggest that during to answer your question directly, in the case of a will, during the testator's lifetime, the testator has the ability to change that will, to amend that will. Contrary to this situation where when the irrevocable trust is established, immediately upon being established, there are fiduciary responsibilities that the trustee has towards the beneficiary. In this case, my client is the sole beneficiary.
Well, that same distinction that you draw in terms of the possibility of a change would apply, of course, to a revocable trust, a revocable trust. I have to be careful in my pronunciation because irrevocable and irrevocable sound too similar. But in the case of revocable trusts, the revocable trust could be revoked, and the property would revert back to the testator, and so the testator remains at all times in complete control of the disposition of that asset. In contrast, in an irrevocable trust, title to the property is irrevocably transferred and vested in the trust itself as a separate entity that survives the testator.
That's correct, Your Honor.
Or the transferor. There is no testator.
Right. And again, just to go back to Walsh and Bostwick, there are the two exceptions that the court created there are when equity requires to avoid a hardship or an injustice. I would suggest respectfully to the panel that in order for this decision to stand, does create a hardship and an injustice to Mary Ann, who has done nothing during the course of this trust to in any way try to defeat, interfere, or in any way change the documents that were recorded, the trust that was created, and the deed of transfer into those trusts.
No, but nothing will restore the real property to the trust itself. This becomes an issue over the proceeds of the sale, right?
Yes, Your Honor. The other aspect that's important is if the court looks at the existing statutory law, I would suggest that the court need not look any further than the existing statutory law, both in terms of the MUTC and the MUPC, to show that both the rules of construction under the MUTC and also under the MUPC make it clear that there is an intention for an important fundamental legal distinction between an irrevocable trust and a revocable trust.
Does it matter, Mr. Karkidi, in this case, that it was not the action of Peter that caused the property to be sold, but the independent action brought in the land court and a court-ordered partition?
I believe it does, Your Honor, because again, that would mean that the land court's action was in ordering the commissioner's sale was incorrect. Because if the land court recognized that the property was the subject of the trust. Now, remember, Peter took the position consistently, and we provided all of the documents in terms of the affidavits of summary judgment, consistently to take the position that he existed as the trustee, held the title to that property as trustee throughout all the entire land court proceeding, only as long as it benefited him. As soon as the land court ordered that property to be sold, and we were talking about the proceeds, the remaining proceeds, he took the position that he was no longer acting as trustee because he wanted to have access to the individual proceeds. Now, the fact that the land court intervened shows, again, applying the cases, that in fact was not an action taken by Peter. It was taken by the land court.
Right, but I guess what I'm suggesting is your position might be stronger if it had been an action taken by Peter, as opposed to responding to a court order.
Because it was an intervening event.
I understand your argument, but Your Honor, if one of the two elements is action for it to be a will substitute, in essence, for the case law to apply into Wasserman, et cetera, would be an action by Peter. Again, the land court as the intervening action was not any action taken by Peter. I know my time is running low, Your Honor. I would suggest that if the actions that preceded this, including the the quitclaim deed and the trust, it really stretches the boundaries of the imagination and reasoning for Peter to take the position that in fact all of those documents do not constitute a single transaction creating the irrevocable trust. The fact that it was an irrevocable trust is undisputed both by the court and by the proposed expert witness's opinion. Finally, Your Honors, judicial estoppel is an option that you have is available under this. And I thank you for your attention.
Thank you. Attorney Shealy, unmute yourself and you may begin your argument. You need to unmute yourself. There you go.
All set?
Yeah.
Okay, fine. Good morning, panel. I'm attorney Frank Shealy from Chatham, and I represent Peter Pullis in this matter as the appellees. And I think the easiest way to start this whole conversation is that the only reason that this document became an irrevocable trust was by default. If that document had been prepared after 2012, it would have been a revocable trust, as the language has changed under the new statute as of July of 2012. But we are clearly dealing with an old law that makes this document irrevocable.
But isn't that important? Isn't that status as an irrevocable trust important?
I think it's a distinction without a difference, Your Honor. I think we're all right that we can't find any cases that talk about revocable versus irrevocable trust with reference to.
No, I understand that, but the purpose, I mean, the purpose of the doctrine of redemption by extinction, as we talked about it before, is to guard against the or to deal with the situation where the will reflects the bequest of a specific article of property that the testator otherwise disposes of during his or her lifetime. And in the case of property transferred into an irrevocable trust, that property already has been transferred, and there can't be a change of mind or other intervening circumstances that deprive the trust of the value of that asset. It may change the character of the asset, but it doesn't divest the trust of the proceeds.
I would suggest, Your Honor, that under the doctrine of redemption by extinction, as to the identity of the object that was referenced in the trust, that no longer exists. And I think it was correctly identified as an intervening
But
legal.
in any irrevocable trust, if the let's set aside, if I set up an irrevocable trust for the benefit of the Museum of Fine Arts, and I transfer into that trust a work of fine art, okay, that I happen to have on loan to the Isabella Stewart Gardner Museum, and lo and behold, that art disappears one night. But fortunately, I have an insurance policy. The trust now holds the proceeds of that insurance policy. Are you telling me that that those proceeds are not available to the Museum of Fine Arts as the beneficiary of my trust?
But I'm suggesting that there's no insurance here. The only thing that's left in this
I'm not
case,
talking about, I'm just, bear with me. When you convert the identified article, the identified asset, into cash proceeds from whatever source, how is it that those proceeds are taken away from the irrevocable trust?
because the trust defined the gift as the article of art, not a cash substitute.
But you've identified no case, neither of you has identified any case where redemption has applied to inter vivos gifts into an irrevocable trust. That's an absolute transfer into a trust vested at the time of the transfer, or at least in this case, at the time that the trust became irrevocable.
That's correct, Judge. And the article of land no longer exists. We all agree on that. There's no dispute. The only thing that's possibly left in here is the balance of the money that the commissioner was holding following the partition. We're suggesting that under the doctrine.
There was no partition, though, Attorney Shealy. Could your client have sold the real estate held by the trust?
Probably could have. I'm
And-
not sure, because the language of the deed that creates this quote unquote irrevocable trust is at best sloppy. It's not a true trust document. It's some language that appears in a deed that establishes
so
what
follow
we're.
me then down this road a little bit. Let's say he could sell it. Who's entitled to the proceeds? Again, no intervening partition action. This is, he sold it. Let's assume he's permitted to sell it. Who's entitled to the proceeds?
That's a good question, because an irrevocable trust would not allow him to sell it without court permission. And then the court would probably direct the necessity for the sale and or the disposition of the proceeds.
Well, no, suppose now you've changed Judge Blake's hypothetical, because she asked you if the trustee could sell it under any circumstances. Let's assume for a moment that the trust authorizes the trustee to sell the property with the consent or approval or at the direction of the beneficiary, because the trust, after all, is established for the benefit of the beneficiary.
But that could not happen, Judge, until Mr. Polis passes away.
Well, why is that?
That's the language of the trust as
Okay.
to how this thing.
But let's take an irrevocable trust that doesn't include that language, because we're looking at this qua trust, not qua will.
Well, then we'd be dealing with an entirely different document, Judge, that we're dealing with in this particular
No, but we are
case.
dealing with an irrevocable trust. I'm trying to, along with my compatriot here, Judge Blake, I'm trying to tease out the essential character of an irrevocable trust and property transferred into that, and the relationship between the trustee and the beneficiary.
Well, if as we know, this is an irrevocable trust, the property would stay in that trust until Mr. Polis passed away. Unfortunately, there was the intervening sale by the partition, so that
Okay.
changes the whole factual background.
Okay, since you're unwilling to examine a trust that doesn't include that language, let's say that Mr. Poulos, during his lifetime, breached his fiduciary duty and sold the property, and then died before the beneficiary was able to bring an action forcing the recovery of that property.
I guess the question then
What
ask,
happened to the proceeds?
what would happen to the proceeds?
Right.
Well, they'd probably go through his estate at that point, Judge.
His estate would the proceeds that were obtained by the irrevocable trust would somehow revert to his estate, and he and his heirs under his estate would benefit from his wrongdoing and breach of his fiduciary duty as trustee. That's an extraordinary result.
Well, the issue becomes what happens to how the funds are mentioned. Is it
You agree with that?
him as trustee, or is him as just an individual? If it's as the trustee, it would probably go into the trust potentially. If it was him individually, then it would go through, passed on to his will through his estate.
He would have no title or other authority to transfer the property except as trustee, because a deed from him personally would be void. The property is entitled in his name except as trustee. So the proceeds would, as a matter of law, necessarily be held by him as trustee and be held by the trust.
I agree with that. The deed would have to go out as him as trustee for the title to be complete.
And the proceeds would therefore the proceeds from that sale would flow into the trust. They would be instead of the property, those proceeds would be the corpus of the trust. Barring anything else, the proceeds, I'm unaware of anything that would not entitle the beneficiary to the trust corpus where that irrevocable trust is held for their benefit.
Except that the identity of the asset is no longer available, Judge. You're substituting one asset for another, and the case law does not
Happens
suggest
all the
that
time
happens.
in the case of irrevocable trusts.
Right.
Mr. Shealy, can I ask you a slightly different question, please?
Your Honor.
Is there any evidence in this record that the declaration of trust we're discussing was part of an overall testamentary plan?
Except that it's the only testamentary document that Mr. Polis is involved in. He has no other assets, Judge.
What is it about it that makes it a testamentary document?
I'm sorry, Your Honor.
What is it about it that makes it a testamentary document?
Well, it acts as just the same as a will. It passes through if the asset is still there, it would pass through as though it passed under a will.
But it's not a will, it's an irrevocable trust.
Right, but it doesn't
It
make
may-
any
it may-
difference
it
in
may-
terms of the passage of title.
Right, but let me try a different.
Basically a will substitute, Judge.
Suppose I set up an irrevocable trust and put into that irrevocable trust a life insurance policy, but it's not a policy insuring my life. It's a policy, let's say, insuring my law partner's life. It's a key man policy, so-called. And my law partner dies. That policy, as a matter of a contract, no longer exists. But what the trust would hold, what my irrevocable trust would hold, is the proceeds of that insurance policy. Those proceeds would be available for the beneficiary of that trust, right?
Would suggest yes, Judge, because of the nature of the policy.
Right. I guess I'm just struggling to understand why a trust, an irrevocable trust that holds property that is converted to a different form for any reason would not have the proceeds from that conversion remain the corpus of the trust.
Well, there were several cases that are cited in our brief, Judge, that suggest that that doesn't necessarily happen. That many times if something
None
is
of them
sold
involves
before-
an irrevocable trust where the title vests irrevocably in the trust and does not remain with the either the settlor of the trust or the testator of the will, where subsequent events could change the circumstances and give rise to a question of what to do after the death of the testator or settlor.
And that's correct, Judge. Everything we're dealing with, at least in the cases cited, are irrevocable. Inter vivos trust. There's no question about
Inter
that.
vivos revocable. This is an inter vivos irrevocable trust.
Correct at this point, because of the nature of the default on the document.
You could also set up a testamentary irrevocable or revocable trust, but that's not what we're dealing with here.
I don't think that's what we're dealing with, Judge.
Do
So there
you
is
agree,
no-
Mr.
Go ahead, Judge Kinder, I'm sorry.
Do you agree, Mr. Shealy, that the judge, it seemed to me that the judge did not address the argument that the doctrine of redemption does not apply to irrevocable trusts? Do you agree with that? I didn't see any mention of irrevocable trusts.
I agree with you on that basis, Judge. I think it was a trust was a trust to Judge Riley as I read this decision.
But you agree, or certainly your expert agreed, that this is definitely an irrevocable trust.
By default, you're correct. It wasn't set up as an irrevocable trust. It turns out that at the time that was established, that turns out to be the law. I didn't learn that till I got involved in this case, quite honestly.
All right. And I'm sorry, I lost my train of thought. Go ahead. I interrupted you.
Okay. No, I agree that at the point in time that document was created, by operational law, it became irrevocable. Under the new code, it would be deemed a revocable trust.
You said that this was your client's only testamentary plan and he had no other assets. And I take you at your word, but is there anything in the record that tells us that?
I don't believe that was recited on the record, Judge.
All right. So there isn't then any record evidence that this is part of an overall testamentary scheme, correct?
Be correct, Judge.
Right.
There's no will that pours into a trust.
Not that I'm aware of, Your Honor.
So if he were to pass, there'd have to be an administration. There would be no probate estate.
That would be my understanding.
Do you have anything else that you would like to say to us?
I have nothing further. Judge will just submit on our brief, and I appreciate the opportunity to address you.
Thank you, Judge. We're live and on the record.
Okay. That brings us to our next case number 2019 P1173, John Doe number 61890 versus the Sex Offender Registry Board. And in the waiting room, while briefing counsel on this argument, I've reminded them to refrain from reference to the impounded material. Attorney Beard-Bader, it's your turn to present. You may begin.
Good. First of all, good. I guess it's still no, it's this afternoon. It's good afternoon, almost. Chief Justice Green and your honors. I represent, my name is Attorney Deborah Beard-Bader, and I represent John Doe 61890. This is a very easy one issue case. And the question that I've presented in the appeal is whether Doe 7083 precludes or precluded in this case the SORB from going forward on finding my client to be a level 3 offender after a hearing that was actually done now 4 years ago, and done at a time when it was entirely predictable that he would be serving time in the criminal courts, which he did, and now is still in custody and has not been released, and now is facing a potential civil commitment for which there is not even a trial date set, because we're not even doing trials yet in Massachusetts.
Can I ask you a question about that? Your brother makes the argument that the SDP docket sheet was not before the hearing examiner and therefore not before the Superior Court judge, and therefore we should not be considering it. What is your response to that?
My response is that you need to consider it because the appeals court.
But isn't it outside the record?
It sure is. It sure is. But the appeals court is interested not in dead records, but in what's happening with a case. And in this instance,
ordinarily, we're most concerned with the record of the particular case, and to the extent that there are extraneous circumstances, there are most often alternative vehicles or avenues to pursue a different form of relief. And in this case, that would ordinarily be a reclassification hearing directed to consideration of subsequent events.
Which might make sense if my client had been given due process in the first instance, but he wasn't, nor is he without prejudice at this point because of that absence of due process and because of a very stale classification that today is 4 years old, and he's not anywhere near being released to the community. Now, the prejudice is well explained in the SJC cases, and in fact, there's one currently on appeal in front of the SJC, very similar to this case with regard to this issue, and that was just argued, I believe, early in March. And so it'll be interesting to see how that one comes out, because in that case, there was even an active waiver by the.
Can I follow up on that? Can I follow up on your point regarding prejudice? Because the board, as you know, makes the argument that even if there was an abuse of discretion in the denial of the motion to continue, that there is no prejudice because given the fact that there were 3 contact offenses in public places here, that the result was likely to be the same in any event.
I disagree with that, Your Honor, and for the very obvious reason that the most mitigating factors that would be applying in this case were not there at the time of the hearing 4 years ago. 4 years ago, the hearing examiner didn't have in front of him what has happened subsequently, including being penalized criminally for that last public case, and further civil commitment plus treatment plus the increase of age plus other mitigating factors that couldn't be in front of him because we were, years away from having anything like it.
At the risk of banging the same drum, isn't the possibility, if not the likelihood, of subsequent events bearing on the appropriateness of a classification after the classification occurs, isn't that always present? And isn't that the reason why there is the opportunity to seek a reclassification?
Yes, but if you haven't been given a fair classification to begin with, you're starting at a level that was violative.
But in assessing that, we view it on the circumstances that were present at that time, not on the basis of subsequent events that may fairly be anticipated but have not yet occurred.
Exactly. And at that time, the facts would be stale by the time he's released. That's why the SJC has been very clear that these hearings can't happen. In that case, 18 months before release.
Well, but
and in our case, it's been more than 4 years.
But he wasn't convicted of the offense for which he was being held at the time, right?
He was being held on that offense, I believe. Yes.
Right. So there was every possibility that he would be released from custody, either released from pretrial detention and then placed into custody upon a conviction, or released and acquitted, or released and having his charges disposed in a plea that involved probation but no time. And all of those circumstances were, at the time of the classification, inchoate, on the table, and without any ability for the hearing examiner to know what would in fact occur.
That's exactly the problem. The arguments that were being made at the time, and I think are well preserved in the record from the counsel, was that that was possible but not probable. And in sex cases like this, where you have a multiply convicted offender with lots of witnesses and lots of strength in the Commonwealth's case, there would be no reason to have to do it at that time. It's what was most predictable to happen did happen, and that's that he didn't get released, that he's doing or did at this point completed a pretty serious criminal sentence, and now is pending a year to life civil commitment. And
but back to the time of the hearing, and he got a second hearing, and so our timeline is altered in some respects because of the heightened standard that the SJC issued in 2015. Putting that aside for a second, your client had the ability to ask the hearing examiner to keep it open or to make a preliminary determination, and that didn't happen here.
And I wonder if that ever happens. I was trying to find a case, and I think this would be a good question.
I think it happens all the time, counsel.
I'm sorry?
I think it happens quite frequently. So my question
that you can leave it open. Well, then that was something that
is, if he didn't do that,
yeah,
that's on him. So when we're analyzing prejudice, you know, he had a remedy that he didn't pursue.
I suppose that could be an argument, at which point it's really the fault of counsel. The other question, though, is whether the hearing examiner could not have sua sponte made that offer. I don't think anything restricted him from being able to say, well, you know, you're right, it's a little tenuous. We can do a preliminary now and then leave it open for a second day of hearing, as my brother, Mr. Bosse, suggests.
As your brother says at page 25 of his brief, as to this issue, failure to raise an issue before an appointing authority, an administrative agency, precludes a reviewing court precludes a party from raising it on appeal. So that's the Springfield case. You know, is the issue waived?
I don't think it's waiver. And the reason I don't think it's waiver is because this isn't just a regular, you know, administrative law position. This
so
is
if
something
it's not waiver, then we go back to the question of prejudice.
The waiver question is what we're, sorry, Your Honor?
I go back to the question of prejudice because he had a remedy.
Yes. I understand
that he did not pursue.
Let's say he waived it. That exact issue is right now pending in front of the SJC. And it appeared to me that it may be that you can't waive that there are certain due process rights that can't not be waived under these.
So just,
situations.
I want to be clear. What do you say he can't waive?
Well, first of all, I don't think my client waived anything. And I think
I understand that, but you said he can't waive that. What's the that in your sentence?
Oh, sorry. He can't waive his right to have to due process. And I think in this,
what is the, I'm going to help focus Judge Blake's question to you, or focus your answer. I'm sorry, her question was clear enough to me. What aspect of due process is it that is required to be preserved, is unwaivable?
Staleness, Your Honor. The whole reason for the statute is that the community be able to know.
It wasn't stale at the time. It was at risk of becoming stale based on how subsequent events unfolded.
That's true. And that's why we try to do these proceedings in a different kind of way. Had he been able to hold it open, and it would have been an interesting question if that had been denied, if that meant that he should have preserved.
Then we'd have a different case, it seems to me. But where he doesn't make that request, where he doesn't avail himself of the opportunity to seek review after he receives an unfavorable ruling. It seems to me the question before the SJC is quite different from the one that we have in this case.
But I think he does seek review. He's gone through the regular appellate proceeding by going 30A. So I'm not sure.
Review of the case, review of the question that was before the hearing examiner, not review of the subsequent events, because those were not before the hearing examiner.
Well, he did start that. I know somewhere in the record he had appealed that particular issue on 30A to the Superior Court in Middlesex County and was denied, and so then had to go through the hearing itself. So I don't know how else he could have reviewed that, gotten review for that. I think the only right you have to review is to go through Superior Court under 30A.
If you had asked for the preliminary hearing, my understanding at least of the case law, which includes Doe 7083, is that he would have been entitled to a continuation of the evidentiary hearing, quote, at a time reasonably close to his actual release date, which would have dealt with the issues that you're trying to raise here. And I'm struggling with, even if, assuming without deciding it's an abuse of discretion, how do we get to prejudice when he had an available remedy that he didn't pursue?
I can only analogize to the question of waiver on the current pending SJC case.
Okay.
It seems to me if you can't waive it, and it's almost, I don't want to say it's a distinction without a difference, but it seems like it doesn't matter that much, because this is the question. If the hearing examiner first of all, the hearing examiner could have just said, let's hold this open. It's perhaps unfortunate that wasn't something that the attorney who was in front of the hearing examiner did, but I don't think it means that this court cannot look at the question of staleness and is forbidden from doing so because magic words were not given and either considered or denied either, because it's a matter of due process and it's a matter of public safety. I mean, what sort of information needs to put him out? And right today, I mean, he's got the prejudice because he's on the internet, and that's accruing while the Commonwealth is getting no benefit from purposes of public safety because this man is nowhere near the public. You'd think, I mean, in a different world, you might think the SJ or the SORB itself wouldn't want to have people on those lists that can't even be in the community for some unforeseen amount of time. And to try for him to, at the time that he gets out, I believe the only time he could ask for a new hearing would be 3 years after he's out. And that may be, as much as 10 or 20 years in the future, given how long these civil commitments can last. I think the issue of, well, I could rest on my brief if there are no further questions.
Seeing none, thank you very much for your argument. Attorney Bossi.
Thank you, Your Honors. May it please the court, John Bosse for the Sex Offender Registry Board. The SORB acted properly by classifying the appellant in 2017 and by holding the classification hearing in 2017, because at any time as a pretrial detainee, the appellant could have been released.
Mr. Bosse, is the failure to ask the hearing be held open waiver, or is it go to the question of prejudice?
I believe that it's waiver because
you don't really say that in your brief, though. You say it's evidence of that the judge didn't abuse his discretion and the hearing examiner didn't abuse his discretion.
Mm-hmm. So it was a remedy available to the appellant that he didn't exercise, and because he didn't exercise that right, it's waived. And so because he had that available remedy to him and didn't exercise it, then
how does the case that was argued to the SJC in March, trying to remember these cases with their numbers always are difficult to summon. 7456 SJC case number 13032. How does that case bear the question of that case bear on this case, in your view?
Sure. I think the difference between that case and this case is that case, similar to Doe 7083, that was decided in August of 2015 by the SJC, there was a known release state with regard to when the offender will be released from incarceration. In this case, at the time of the hearing in 2017, there was no known release date. The offender could have been released at any point. But I do think that 7083, as well as the case in front of the SJC, basically the point of both those cases is that there has to be a classification level at a time close to the offender's release date, or as a result, there's a risk that it could be still.
So what happens to this classification now that he's been held all this time?
Right. So, after I wrote my brief and I was thinking about the issue in this case, right now, the plaintiff or the appellant is awaiting his trial in the SCP case. So at this point, the SORB's concern is that he could still be released from civil commitment at any point if the
Well, I understand that, but the fact of his classification 4 years ago is at risk of being stale.
Right. So, and what I was thinking about in this case, and what I discussed with the general counsel at SORB, is that if he is civilly committed as an SCP, then at that point we wouldn't have a known, we would have an idea of his release date. And I know it's I don't think it's for this court, but I would encourage Attorney Beard-Bader, if her client is SCP, then to write to SORB and say, would you consider provisional status or preliminary status because of change in circumstances? So SORB, recognizes, similar to a lot of criminal cases, there's a change in circumstances. So we have to adjust. For example, in another case I had, we classified the sex offender. Opposing counsel shortly after that wrote to me and said his state prison sentence just dramatically increased. As a result, she asked us to place him in the preliminary status, and we did so because his sentence was then, further out in time.
Well, but then what happens? It's in preliminary status, and then is there a new hearing with new evidence as they approach the wrap date?
Right. So similar to other sex offenders who have been civilly committed, they have what's called, under the SCP statute, a Section 9 trial. So what SORB does is, if opposing counsel requests a second day of hearing, we will hold the second day of hearing within a reasonable time of the Section 9 trial. So I think that could be the future remedy in this case. If the appellant is found SCP, Attorney Beard-Bader could write to the SORB and say, could you please consider these changed circumstances and consider placing my client in preliminary status? Because as an SCP, let's face it, he could be in there for a very long time. And I think
Mr.
that's—
Bosse, I have two questions for you.
Sure.
One is, because he didn't request a preliminary determination, I am presuming that he has been finally classified and it's been disseminated on the internet. Is that correct?
That's correct, Your Honor.
So I'll ask a follow-up to that before I get to my second question. if he is SDP and Ms. Baird Beta writes to you, what happens technically? Do you then pull that from the internet and put it in pending status?
That's correct. So all dissemination stops.
Okay. Any reason that we should stay this case pending the SJC decision?
I don't think that's a bad idea. I just think that right now, what I can see is the big difference between the SJC case and this case is that it seems to me in the SJC case, there's a known release date for the offender, as opposed to this case. In 2017, there was no known release date, and currently, because the SCP petition is pending, there's no known release date. But I think we could benefit from that SJC case, because they may also, I think they may also go into the topic of dissemination while the offender is incarcerated. I believe that may be a live issue.
We're sort of in the position the hearing examiner was. We really can only guess at what subsequent events might unfold.
Right. Correct. So that is basically what I had for the court this afternoon. Unless the court has any questions, I would be happy to rest on my brief.
You're live and on the record.
That brings us to our sixth and final case on our hearing list today, case number 2020P1113, Lindsay J. Savvidis versus Konstantinos Savvidis. Mr. Estes, you may begin.
May it please the court, Chief Justice Green. I would suggest in essence that this case comes down to a question of what I would refer to as parental discretion, sort of behind all of the rulings. That's what was driving this case. My client sought to enforce his parenting time in the summer of 2020. And that's because he believed and continues to believe that his son could safely travel to Greece at that time, because he believed that airline travel was safe. He understood that the rates of COVID in Greece at the time were relatively, well, some of the lowest in the world. And he recognized that the threat of COVID to children under the age of 5 was relatively low. In light of the pandemic.
Are you contesting the judge's finding that the defendant was not guilty of civil contempt?
Yes.
So under the Burchell case, and I'm not sure if you cited that, there has to be a clear and unequivocal order, and assume for purposes of my question that there is. There has to be a knowing and willful disobedience. So could you help us to understand how concerns about COVID, which reasonable people can disagree with, is willful disobedience?
Well, because the court order clearly indicated that she was to produce the child for 6 weeks of visitation in Greece. That's what the
court order also. Well, if I may, just for a moment, I want to step back to an earlier part of the court order. Court order also clearly required imposed a precondition for that obligation to attach.
Yes.
And it's uncontested that precondition was not satisfied.
That is correct, Your Honor.
But you contend that the pandemic absolved your client of compliance with the precondition, and yet preserved a knowing, a clear and unequivocal character to the command that rendered the failure to comply with the second part of that, despite the failure to meet the precondition, to be contemptuous.
That's true.
I will confess to you that I'm having difficulty following you along the entire trajectory of that argument.
Your Honor, the reason that his failure to provide notice per the agreement on May 1st, the reason that is not a breach of contract is because it was impossible for him to comply with that provision.
I understand that, but we're dealing with a contempt here, and rather than a motion to compel compliance with the order. And if you had gone back to the probate and family court seeking an order based on a material change in circumstances that she would be required to produce the child for travel, despite the failure to meet the precondition, on grounds of impossibility, we would be in a very, very different posture. And who knows what the judge would have ordered at that time. That's not where we are. Where we are is the question whether the failure to produce the child after the non-satisfaction of the precondition to that obligation, albeit on likely excusable grounds, whether that failure was contemptuous or contumacious or whatever the term is that we use in these circumstances.
Well, I think Your Honor, your argument presupposes that the failure to comply with that provision in any way excuses her complete noncompliance with visitation that summer. There's no question that the court order clearly states that she's to produce the child on the 4th day after preschool ends, and that he's going to be with the father.
But the court, it seems to me, has at least some room to engage in the question, in the interpretive question of whether the presentation of the tickets operates as an independent obligation or a condition precedent to the obligation to produce the child. And it seems to me also that it is at least a fair reading of the order that treats it as a condition precedent. And if there is significant ambiguity about whether it's a condition precedent or an independent obligation, then that goes against willful disobedience of a clear and unequivocal command.
But Your Honor, if the non-performance is excused by impossibility and that non-performance has no impact whatsoever on her ability to comply with the court's order, I would suggest to the court that it is a clear and unequivocal order of the court, and her failure to comply with it was contemptuous.
You know, it's interesting to me, as I sit here today, I'm beginning to anticipate the emergence from the pandemic, but this case is illustrating that we will be dealing with the byproducts of the pandemic for quite some time to come. I want to go back, and not that it bears on the narrow legal question of contempt here, but just out of, if nothing else, curiosity. Was there any effort to go back to the probate and family court for a modification of the order, or for an order to compel enforcement rather than a contempt?
No, Your Honor, we filed the complaint for contempt, and given the court's ruling, felt that an appeal was the only reasonable recourse at that time. The court seemed to believe that the mother's actions were entirely justified by the pandemic. The court expressed its quote unquote serious concerns about travel during the pandemic,
well, if we had that question in that posture on a request for enforcement of the order, we could evaluate independently whether the judge's finding on that question was in fact an abuse of discretion at that time. But that's not even the question that we have. The question that we have is whether these facts constitute a civil contempt.
Your Honor, I would suggest that when it is impossible to comply with a term of a contract, the next question then becomes whether the other party somehow their performance was rendered impossible. And when you
not a question of whether it was rendered impossible, whether they were excused of the performance despite the failure to meet the precondition, and that raises an interesting question, but one that was never examined, and certainly one that a lay spouse under a support, or a custody order should be held to evaluate correctly, in my judgment, under threat of contempt rather than an effort to enforce. But I'm revealing my general assessment of the posture of the contempt.
Well, let me just add to that, Attorney Estes, maybe you can help me with this. I know that you refer to this as a breach of contract, but as you know, child-related issues merge as a matter of law, and they do not have independent significance for purposes of contract law. So we really, all we have in terms of available options is the filing of a complaint for contempt or a modification to change what was supposed to happen in 2020. And I think that the judge could have entered paragraph 1, adjudged her not guilty of contempt and left it at that. But I see paragraph 2, which you challenge, as a effort to preserve something. Granted, I'm not at all suggesting it's the same as having his son in Greece, but you contend that the judge didn't have the authority to do that. I'm wondering if you're familiar with the Blocksberg case, which says that a judge can modify on a complaint for contempt. And if that changes your argument.
Well, I believe that's incorporated in my argument, that to change a separation agreement or to change provisions related to children, a court has to find first that there's been a material and substantial change in circumstance, and that the change is in the best interest of the child. And the court didn't hear any evidence about that at all. I would suggest
it not implicit in her judgment that COVID-19 was the change in circumstance, that it was for the summer of 2020 only? She makes that very clear at the end of paragraph 2.
Yes, and I would suggest that she can't make that on a record devoid of evidence. She can't take judicial notice of the pandemic and say that that relieves parents of the obligation to abide by parenting orders, which in Chief Justice Casey's open letter to the public, he specifically addresses the fact that parenting orders are in effect. People were in a state of hysteria. I mean, people were
Did you request an evidentiary hearing pursuant to Rule 43?
I did not. I offered in the hearing itself to the court, I said, if the court wants evidence on this issue, we are happy to, to provide that evidence. But from my client's perspective, we weren't seeking to modify the court order. We were seeking simply to enforce it.
And I apologize. Do we have the transcript from that hearing?
No, we didn't order the transcript because the court didn't take any evidence and didn't hear from any witnesses. So there wasn't any evidence to present on appeal. So what I would argue to the court is that once the mother indicates to the father that she's not going to comply with the order and allow the child to travel that summer, the remedy for him is not a complaint for modification of the order. He's seeking to simply enforce the order that exists. And his argument is that her failure to comply with the order is not justified in any way by his non-compliance with the May 1st notification. He, in fact, gave her notification later that month. And she, at the hearing, provided nothing in argument at all about how somehow that late notice by him rendered her compliance impossible or somehow justified her non-compliance. What it really came down to was a fear or a belief that it was unsafe for the child to travel during the pandemic. And the father disagreed. The father believed that it was safe for the child to travel. If this needed to be a complaint, if the mother wanted to modify the agreement, she could have sought that either in her answer or filed an independent complaint for modification based on the pandemic. I would suggest that the burden, if the mother wanted to change the parenting order and argue to the court that it was so unsafe due to the pandemic that the child shouldn't travel to Greece, the burden was on the mother to do so. There was a clear order in place. And because his failure to comply with the May 1st notice was excused due to impossibility, which in no way affected the mother's ability to comply with the court order, the mother should have produced the child for visitation, for travel to Greece. And as I said, if the mother didn't agree with that, she could have filed a complaint for modification, which she chose not to do.
I have a feeling I may live to regret this question, but did the father produce the required documentation on May 1st of this year?
Yes, he did. The child is traveling to Greece this year. Okay. Yeah, he complied with the order.
So, okay. Thank you.
So the father believes that he was wrongfully denied 6 weeks of visitation, and he would seek that the mother be found in contempt and ask this court to remand the case back to the probate and family court for a remedy. And a remedy essentially would be to make up for this missed parenting time. Again, Your Honor, I don't believe that a complaint for modification would have been appropriate at the time because he wasn't seeking to modify the order. His non-compliance was due to impossibility and created no prejudice whatsoever for the mother. What this morphed into was the mother's concerns about COVID-19 and the pandemic, which were adopted by the court. But there was no evidence provided on that. And I mean, reasonable minds can differ as to what is safe or unsafe during the pandemic. So for the court to hang its hat on his failure to provide notice on May 1st as somehow justifying her noncompliance, I would suggest, absent the pandemic, no one would be making that argument.
You said that there was no evidentiary hearing. But you persist in describing the failure to comply with the condition precedent as excused by impossibility. Was there evidence of the impossibility presented to the judge?
Well, the court made a finding of fact that the father's failure to comply with the May 1st order was due to impossibility due to the pandemic. The judge specifically made that finding.
But the judge did that on the basis of judicial notice of the pandemic. Is that how we're doing that?
Your Honor,
I'm just asking the question.
Yes, I suppose you would have to say that she took judicial notice of it because there was no evidence of it. Because
it seems to me that the same considerations that apply to the judge's assessment of the mother's failure to produce the child likewise apply to the determination of impossibility that you rely on for excuse of the condition precedent. But for the pandemic, the failure to produce those tickets on May 1st would relieve the mother of the obligation to produce the child, correct? Well, Your Honor, the fact of the matter is the bottom line is the airlines weren't selling the tickets. That's why he couldn't comply with that order. Well, I mean, you're saying that, but that's not in our record. Well, Your Honor, yes, Your Honor, but I don't think it's, but based on the, logically speaking, if the court finds that it was impossible to comply with the May 1st. We could make that finding if we had evidence to that effect. I mean, I guess it's a little hard for me to hear your protest to the judge's consideration of the pandemic in assessing the mother's failure to produce the child without applying the same protest to your argument, your claim of impossibility. Your Honor, may I respond to that? Yes, you may. Question. Your Honor, I think that the question really is, and it's addressed in my brief, which is that his failure to comply with the May 1st requirement due to the pandemic, I don't think then extends to allow the mother to simply refuse to produce the child due to a general fear of the pandemic. It was literally. You have your argument on that point. Thank you. Thank you. Do the members of the panel have any questions for Attorney Wetstein?
Not that I prepared.
And I do not either. So that will conclude the argument in this case. The case is submitted, and that will also conclude our session. I want to thank our. Can't hear you.
Chief, you're muted for some reason.